People v. Sin.
Good morning, Your Honors. Tom Iwanu, and I represent the appellant Hussein, and I'll be asking 4 minutes for rebuttal.
4 minutes?
Yes, please.
Yes.
The testimony of the sisters of the uncharged violent rapes should not have been admitted into this case, and the lower court erred in agreeing with its admissibility. Initially, the lower court said that it was necessary to complete the narrative and talk about the family dynamic. That's not true, because the one that talked about it was the victim in this case, Iser B. Iser B gives you the background. She says he's the older person.
Counsel, sorry to interrupt you, but your brief and I believe the People's brief do not address the effect of this court's decision in People v. Weinstein on your argument. Could you give us an indication of your view of that?
Correct, Your Honor. Absolutely, in light of Weinstein, this case should be reversed. Weinstein talked about the fact that prior or other witnesses or Molyneux witnesses should really not be used for forcible consumption, forcible compulsion or consent or delay in calling the police. That's exactly what we have here, and absolutely the court should consider Weinstein.
Why isn't it unlike Weinstein? Why isn't it evidence of a common scheme or plan?
It's not evidence of common scheme or plan. One of them was 6 years ago, and it was in Salt Lake City with the one sister, and the other one was when he, not in front of the children, and he got the other sister, Saba Day, alone inside the house after asking her to help carry a piece of furniture in. What it really shows...
He's a familiar, well, the allegations are he's a family predator. So the fact that some years have, there's a gap in the time frame may be explained by that family dynamic. Again, that is not Weinstein. Weinstein is a very different case.
Right. I don't know that a gap in time explains the family dynamic as it relates to the defendant. But what you have are this man's propensity to attempt to rape his sister-in-laws. You have repetitive acts, which are attempts to rape his sister-in-law. You're looking at several different offenses to come to the conclusion that he should be convicted of this one that he's charged.
So that evidence you're describing comes in through the testimony of the two sisters-in-law, right? But it also came in initially on cross-examination of the ER, the head of the ER, the head nurse at ER, right?
I'm sorry, could you repeat that, Judge?
Yeah. The first time that any testimony came in that the defendant had sexually assaulted or attempted to sexually assault one of the other sisters was actually adduced by defense counsel. Yes?
That's right, Your Honor. There was a strategic decision Mr. Davis made because in the pretrial rulings, Judge Varnese had ruled that that testimony was coming in and was coming in the case in chief. So as a strategic
then he brought it out on
mechanism.
cross-examination from the nurse.
Exactly.
And then the next time, another time that it comes in not from the two sisters is from the complainant herself.
Yes.
And you're not arguing that that couldn't come in?
Your Honor, I think, again, it's more prejudicial than probative.
Well,
Certainly, it's nowhere near as damaging as allowing the two sisters in the case.
There was no objection when she testified.
There was no objection. That's correct, Your Honor.
And you haven't argued that that's an error?
It's not an error, Judge. I do not think that it should have been allowed in for the same reasons because those acts are heinous. Testifying about...
Well, she's testifying what he said during the course of the attack on her. That's what her testimony is, right? As to what his words were.
Yes, what his words were is, I'm waiting on your sisters, and I tried it on your other sister. That's correct. Now, maybe if that came in, you could still make a credibility judgment based on weighing the credibility of the alleged victim. But in this case, that's vitiated. It's vitiated because now you have the two sisters coming on, talking about very heinous acts that are clearly propensity to rape the sisters, clearly repetitive acts, and it doesn't pass the second prong of the Molyneux test, which is prejudice versus probative. It's just impossible, in my mind, to get a fair trial, and I think the presumption of innocence pretty much goes out the window once those sisters are able to testify about acts that are very similar in terms of the violence and in terms
But
of
can't we also
pulling up
come
the
to the
skirts.
conclusion that the jury didn't rely on the testimony of those sisters? Because during readback, I believe they asked for readback of the victim, survivor, and the two sisters, and then after hearing the survivor's testimony, they said, you know what, we're done, we don't need to hear anything else. What can we make of that?
Can't unring the bell. They did, what I think is significant, is that they came out and they asked for the sister's testimony. So that means it was weighing on their minds in the jury deliberation. They've already heard that. That's already in the jury room. The mere fact that they wanted it is significant, but the mere fact that they
They
made
wanted
the
it, then
decision-
they hear the survivor's testimony, and then they wave it off. They say, we don't need to hear anything else. I think there's an argument that could be made that they're not relying at all on the sisters.
I think, with all due respect, that's supposition. We don't know what was going on with the jury. We know two things. One is they wanted to hear it. They thought it was significant enough, I think there were very few readbacks in this case, to ask for the entirety of both Molyneux sisters to be read back. And then after they heard the victim in this case, they may have felt that hearing the victim combined with the allegations with the two sisters warrants a conviction. So you don't know if they made that conviction based on the independent judgment of credibility or based on the two sisters. And
I
that's the
have another
problem.
question, because I'm not sure the answer to this. When the judge was charging the jury charge, how did he or she charge that testimony? As common plan or scheme, as background, as
It was a
completing
number of things.
narrative? What was it?
It was a number of things, common plan or scheme, motive, intent. It was a broad, general definition, and it was not very specific.
Similar to what he said when the evidence was coming in initially?
Correct, correct.
He expressly said you can't consider it for propensity in the
For
instruction.
propensity, right, Your Honor. But you can say that all you want, but you're not going to ring that bell, because if there ever is a case of propensity, this is four sisters married to one who's pregnant, attempted to rape the other two, and now the jury hears about attempting to rape the other two. And what's really significant in my mind, and I would ask for the court to weigh it, is especially with Nazima. Nazima is the first sister to testify. She testifies about a very violent rape attempted rape, where he tells the kids to leave, and he grabs her and he pulls up her traditional skirt. Almost nothing about the family dynamic, almost nothing but the facts of his propensity to rape. And then almost as an afterthought on redirect, the prosecutor throws in 3 or 4 questions about culture. This is clearly a propensity case. This is clearly a repetitive acts case. This is,
And in Weinstein, was the jury charged not to consider that evidence for propensity?
yes, again, you can't unring that bell. You can be told not to do that, but once it's in, it's already so prejudicial, you're not going to get back to a fair trial. I can't
So are you
imagine.
suggesting, even when there's a limiting instruction, that juries are presumed not to follow the court's instructions?
There are some times, Your Honor, that a limiting instruction just does not complete there's sometimes that the limiting instruction is not going to work because the testimony is so heinous and so persuasive that you can't get past it. You can't unring that bell. And by giving a limiting instruction to a jury after they've heard something like this is not enough. There are times there's case law when they say.
Does the issue about the limiting instruction go to the question of whether or not the evidence was wrongly admitted, that is, that it's an error, or to whether or not it was properly admitted because it fits under an exception, but it's so highly prejudicial?
It's
Which argument are you landing this particular statement on?
it should not have been admitted in the first instance because.
If we disagree with you, and we think it fits under an exception, is your only other argument that it was so prejudicial?
Absolutely, Your Honor. It has to meet the second.
Regardless of what the judge charged?
I'm sorry?
Regardless of what the judge
Yes,
charged.
regardless of what the judge charged. You're looking at the second prong of Molyneux, which is it more prejudiced than probative? A judge with a limiting instruction is not going to erase it when you are talking about attempting to rape 3 of the 5.
It sounds like that rule would mean you could never, even if fit clearly under an exception, have evidence related to a sexual attack.
You know, I've pondered that question, and I'm sure there may be times when it could be admitted, but given the facts of this case and the facts that the fact that it's so heinous, and the fact that it is the sister-in-laws, and not just one, but 2. So the jury is logically going to think, if he attempted to rape the other 2, even if there's some doubt in my mind, because there is no physical evidence in this case, that he raped the victim.
It sounds like a
in this-
common scheme or plan, considering the way the act was conducted, right? Considering his actions.
Yes, in one sense, it's a common scheme or plan. In the other sense, it's repetitive actions and propensity. And I think when a jury hears a particular fact...
Well, the
in this-
assumption is on a common scheme or plan that it's an exception, because otherwise it would suggest propensity, right?
Correct.
That's the point.
Correct. Again, it doesn't get past the second prong of the Molyneux test. It doesn't solve the family narrative. It doesn't solve the family dynamic. A limiting instruction is
Why,
not
well, why
gonna
is
carry
that?
the
I don't really understand your, I can somewhat appreciate the argument on the common scheme or plan, but I'm not sure I understand why it's not giving information to the jury to help the jury understand what went on amongst the sisters, why they might not speak out, why he might conduct himself in a particular way.
As Judge Ogden said in her dissent, it's unnecessary. Iser B., who's the first one to testify, gives far more of that.
Yeah.
She gives the entire family dynamic. She gives the history, the narrative.
Yeah.
She gives it all. Nozema, again, gives it only on redirect, I think because the prosecutor felt even though it was propensity, they had to throw it in. And Swabeda, the third sister, gives almost nothing whatsoever. So you don't need it for the narrative, and you don't need it for the family dynamic. In fact, in his 7-10-30 to the
Except in
police...
that argument, you assume they're going to believe her.
I'm sorry?
Except in your argument, that assumes the jury believes her, right? And I would assume the people want to show that this is not some story that she has constructed. It's supported by the actual family dynamic.
Well, actually...
Because
the
his
seven-
argument is
the
by
s-
consent, right?
The 7-10-30 through the defendant who says, I own you,
Yeah.
and her statement that he talked about his relationship of respect and that he waited on the other sister and tried it on the other one, you have it. You don't need to, for this little portion of family dynamic, you don't need 2 prior violent attempted rapes of a sister. Doing a balancing test, it should bode in favor of the defendant, so he has a fair trial.
Thank you.
May it please the court, Michael Hillary for the people. There were several non-propensity reasons to admit this evidence.
You want to address Weinstein for starters?
I don't believe Weinstein definitively addresses this case, Your Honor, because I think if I read Weinstein correctly, it was predominantly concerned with the issue of intent. And I think in Weinstein, again, if I'm reading it correctly, this court determined that the issue was not so complicated as to require a succession of incidences of similar conduct.
It seems hard for me to understand how you could have a family predator exception to Weinstein, which was really an aspiring actress predator case, right? What's the difference? Why would a family predator be different than an aspiring actress?
Well, Judge, I think the argument that I'd like to address to this court, which is somewhat related to that question, is the background. And the fact that we're dealing with a different culture, a Burmese culture, with different language.
That argument was made in Weinstein, right? It's a different industry, it's a different culture, it's why people would do things or not do things. How is that different?
Because it tends to explain the odd, if not absurd, testimony of the victim in this case. It may seem absurd to an American jury, I think, the description of how this incident occurred when the victim was the sister-in-law of this defendant. They had lived together for many years.
How is that odd? We have cases where parents are accused of abusing their children, so I don't really see the point of your argument there.
Well, this defendant entered into this bedroom unannounced, uninvited. He sat on her bed. He propositioned her. Before he laid a hand on her, actually, even before that point, he had shown her a piece of mail that was purportedly something he needed to show her.
Okay,
And then
you raped her, and she reacted the exact same way that I think you would suggest a victim of a rape should react. And she screamed, and she yelled, and she banged the floor to get someone's attention, and then she promptly outcried to many witnesses, and she promptly reported this to the police, unlike the survivors in Weinstein.
Well, she was apprehensive, Judge, even at the point that he was showing her mail.
Well, of
That
course
was,
she was
the testimony is apprehensive, but this is her brother-in-law. This is someone that she's
You're
known
not
since she
really-
was young.
You're not really saying that there aren't cases of people being raped by relatives, that that's uncommon.
No, Judge, I'm not saying that at all. But I'm saying that if a jury is listening to this case and they're hearing that this family has lived together.
How do those prior assaults go to her reaction to him bringing her a piece of mail?
Well, if she knows that her sisters have been, well, that's a good question, because she is apprehensive according to the record. That's her testimony.
And
But
is
if
there
she knows-
testimony she knows?
She knows that her sisters have been abused at his hand, and here he is under somewhat odd circumstances. She can't even read mail. She can't read English. Why is he here? Why is he showing this mail? Why is he coming here when my husband is away and I'm here alone, not feeling well with my 4-year-old? I'm a captive audience in my own home. They live downstairs. There's no other male figure there but him.
So it's to explain her apprehension about him coming in her bedroom with mail.
Well, I think her reaction is given context. It's given some background that allows a jury to see it. The jury has to, the people have to get a fair.
It's giving background and context to what? Because I thought this, when this type of thing is admitted for background, it's to explain the defendant's conduct, not the victim's state of mind. So
It does both, Your Honor, because the defendant, recall, the record indicates the defendant returned to the scene of a rape, very short in time. I mean, he was there when the police showed up, the defendant showed up
Well, it's
momentarily.
just-
Why
it's-
is he returning so quickly to the scene of the crime? And
It's his home, isn't it?
Well, it is, Judge, but if he commits a crime and she reacts to him the way that she allegedly does, which is screaming, yelling, he's got his hand over her mouth, she's trying to get out of there, why would he return so quickly?
She goes, she's gone.
She does. And I propose to this court that he has some inordinate level of confidence that this matter, like the other two with the sisters, will go away,
We often
which
say
it
that,
did.
we often say that flight indicates guilt, and maybe returning home indicates, hey, nothing really happened here.
It's a hard stretch to say you have to put in 2 prior similar sexual assaults to explain why he's in the house, right?
Well, that's not all, Judge. That's not the only value of the testimony. We're also showing an absence of mistake. Remember, he put his own state of mind.
What could the
An absence
mistake,
of
what could the
mistakes?
mistake be? Right here.
I'm sorry,
What could the
Judge.
mistake be?
Well, the mistake would
Whose
be
mistake?
that
His
he,
conduct or her understanding of the conduct? What do you-
both, Judge, because she's
Given the
understanding.
testimony, how could there be some theory of mistake, given what she says happened between them?
Well, the defendant's position is, I was just doing what I always do with these sisters. It's banter, it's playful, it's not a real power play. I'm pretending I own them, but it's a joke and everybody knows it. Her position is absolutely not. He came in with force. Essentially, he came in to get his will.
Counsel, I mean, I don't fully understand what the mistake is, but even if I could wrap my head around that, I think after Telfair, which tells us when these events are separated by years, they take place in different locations in geography and even different locations in the home, there's no commonality that would connect those prior 2 events that would inform anything about mistake. And I don't understand how you can argue that that's an applicable exception here.
Well, I think that it goes to her state of mind and it goes to her understanding of what's happening versus his proposed understanding of what was happening. He did put that before the court. He put that before the jury. I was joking. I know this is a statement he made to the police, which was in evidence. I was joking. I didn't mean any of this like they, you know. she
Well,
might have
isn't
thought
that
I did.
intent, and didn't we put that to rest with Weinstein? And the same thing with background or power dynamics of sexual assault. I mean, I think everything that you've tried to convince us is important under Molyneux, I think this court has rejected under Weinstein.
Well, I don't know that Weinstein, I don't see Weinstein as speaking to the nuances of this case, really, which are cultural, religious, ethnic, and I will say that the defense
Power
attorney.
dynamics of men with power over women seeking to be actresses. I mean, the background is the background. I'm puzzled by a common plan and scheme because those assaults were not committed in the same way, right? The two earlier ones, so I don't see how it's a common plan or scheme. And in fact, I can't think of any cases off the top of my head of a sexual assault or a rape case relying on common plan or scheme alone.
Well, I agree, Judge, and we're not arguing that this is exclusively a common plan or scheme. I think this is an example, frankly,
Court
of going.
below held it was.
I'm sorry, Judge.
Didn't the court hold that it fit under that exception?
Among others, yes. Yes, it did. But it also, the appellate division looked at background as being relevant, understanding the family dynamic. And I think that that's important here. I think we're dealing with cultural nuances that were simply not present in Weinstein.
I'm still not grasping how the cultural background or nuances are different. They may be different in the specific, by which I mean, what are the particulars of this person's life experience? But aren't both about, what is it about the power dynamics that shapes both the victims and the accused behavior? How are they distinguishable?
Well, I think that in this situation, Judge, it's much more culturally dependent. And a proper understanding of what happened is much more rooted in cultural differences than in Weinstein. I think
But-
Weinstein is more easily grasped, by an American jury.
Do you
than-
disagree? Well, then maybe you're saying it's less necessary, but do you disagree that in both cases, what there was an effort to get at was to explain why the power dynamics might be as they were and how they would have impacted the behavior of both the victim and the defendant in those cases?
That is true.
Okay,
I
so-
agree with that, but I think it was more vital to a jury in this case to have the background, to explain the nuances of that dynamic than was necessary in Weinstein.
But how is that true? Because in this case, the victim outcried immediately. She went to the police. There was clear indication of her struggle. There was violence and clumps of hair. And you're saying that you need that Molyneux evidence here in light of all of those facts, when we've said you didn't need that kind of evidence in Weinstein, which had none of that, which had issues that were, consent was blurred, that had the same kind of sexual and power dynamics that you're describing here that were not as overt here. So we've already rejected that, and that's why I'm having a problem now adopting your argument here.
I would just note, Judge, that the appellate division dissent didn't see it that way. They found according to the dissent, there was no physical evidence of a forcible rape here. And defendant put before the jury that, in fact, the defense attorney put before the court on multiple occasions that the only reason, quote unquote, we're all here is because the victim's 4-year-old son discovered his mother in the act of consensual sex. And now she's got to do damage control. That was essentially what was put before the jury by the defense here. So I believe that there are, that the people had argued below that there were cultural differences that explained the air of entitlement with which the defendant entered the home, expected to get his way, the things that he said,
You
using,
don't think there's something a little distasteful about determining Myanmar culture based on the dynamics of this particular family?
well, I think the witnesses indicated that this was a part of their family dynamic. And I think, yes, it is cultural to a degree, but it was specific as well to this family. That's what the testimony indicated, as
So
far as
then,
I can.
isn't in part the difference from Weinstein, that in Weinstein, the prosecution's argument and the defense sort of going back and forth about whether or not it's consent, his intent, his understanding is that that's what he offered in the industry, right?
Right.
Sex for the ticket to a career in this industry, which is not what the prosecutor and the defendant were arguing about here, right? I mean, if anything, the prior violent attempts at rape with the sisters show that that is not, he did not expect, other than the act itself, to give them anything.
Right, right. Well, I would also note too,
Weinstein would be limited to career benefit type evidence.
oh, I'm sorry, would it be limited to that scenario?
I mean, I don't understand the distinction.
I don't mean to make that distinction. I think that's sort of a blinkered way to, and I hope I'm not
Would
addressing.
it be
the point that way.
limited,
I don't mean to.
you know, to situations that involve domestic American families? Because I feel like one of the upshots of your argument is if background is necessary to explain the cultural issue here, and you're dealing with a case with a family predator, it could only be valuable in a case involving a family predator from another culture. So you bring it in for the immigrant families, but you don't really need it for the multi-generational American families.
Well, Judge, I think it's a matter of, it's discretionary. I think the court has to look, and this court is uniquely positioned to look at all of these nuances and facts and decide whether or not, yes, it legitimately fits within the category and is not so prejudicial that it'll prevent defendant from having a fair trial. The people are entitled to a fair trial, too. My initial point, I do think that, it does tend to explain the victim's reaction here as well, is a significant one. She virtually started fleeing before there was any real obvious threat of physical harm, right? I mean, he comes in, he does what he does with the mail, and she's already apprehensive. She's already looking to get out of that situation. You're a jury there listening to this, and you're wondering, well, what gives? This is your brother-in-law. Do I really trust that your accusation is true? You're saying you're reacting this way. Are you overplaying your hand, basically, by saying that? I mean, I'm looking at it in the sense that, the defendant returning to the scene when he did, as early as he did, the victim's flight before flight seemed absolutely necessary. The circumstances of his entry into the comfort level with which he entered there, it seems to me to be a story that a jury might have problems with unless they had other background information to put those acts and that behavior in context. Unless the court has any questions, I'll rest. Thank you. Thank you.
I'm going to be very brief, thank you. There was no necessity for the other two sisters, even if the prosecutor's correct. All that information about family dynamic and culture, with the Burmese culture, comes from the victim in this case and the defendant. The other two sisters add literally almost nothing. It is propensity and it's repetitive acts. And in terms of responding to what the prosecutor said about the actions of the complainant, the actions of the complainant were that she ran out the door. She went to her house because someone in her house spoke English. And at the house, that person called the police came over, and she went to the hospital. So there is no need for extra explanation based on her behavior afterwards. Thank you.
Thank you.